Hello everyone, I welcome you back to our channel. This is Legal Mindset at the back, and today we are going in for Constitutional Law 2. We are going to look at a paramount, sacrosanct, and very important topic for your understanding of constitutional law. If you want to become a good constitutional lawyer, you should understand this topic very well. So, this is the topic of rule of law, one of the core topics in the course unit. So, I urge you to be very attentive, keen, because it is so technical. So, subscribe such that we can continue with our topic. Now, the rule of law means that powers and functions should be exercised in accordance with the law. So, you should be very keen on the way you answer the topic rule of law, because you should show how Uganda has observed the rule of law. You should also criticize, give the criticism, how has it not met the standards of rule of law. So, to dive into it, I'm going to give you a number of authorities which define the rule of law. And as a bonus, I will take you through the fundamental legal principles that govern the rule of law. So, according to ECS, Ward and Godfrey Phillips, in their book, Constitutional Law, 8th edition, at page 52, they define the rule of law to mean that the exercise of power of government shall be conditioned by the law, and that the subject shall not be exposed to arbitrary will of the ruler. In this we see that both the ruler and the subject are under the same law. No one is above the law. We are all equal under the law. And if you go to the book of Justice Kanyai Amba, Constitutional History of Uganda, it stated that the funny thing about the rule of law is that the people who are led and the people who are leading are all controlled and governed by the same law. So, the origins and the notions of the rule of law were expounded by Professor Albert Van Dicey in his book, The Law of the Constitution, 1885. And according to Professor Dicey, the rule of law basically meant three things. Number one, supremacy of the Constitution. Number two, equality before the law. Number three, just government. So, as I told you at the beginning, we are going to marry Professor Dicey's idea with the events that are happening in Uganda. We also marry it with the 1995 Constitution. To begin with, the supremacy of the Constitution. If you go to Article 2, Clause 2 of the 1995 Constitution, it emphasizes the supremacy of the Constitution. It provides that the Constitution is the supreme law of the land. If any other law, custom or norm is inconsistent with the provisions of the Constitution, that other law, custom or norm shall be void and the Constitution shall prevail. You can look at a number of cases that emphasize the supremacy of the Constitution. For example, the case of Major General David Tinyefunza versus Attorney General, where Tinyefunza was subjected to forced labor, as Professor Kanyai Amba said. Justice Kanyai Amba said that as Tinyefunza requested for resignation, maintaining him to work in the army was subjecting him to forced labor, which was against the provisions of the 1995 Constitution, the supreme law of the land. And the court held in the favor of David Tinyefunza. So you can look at other cases. The case of Salvatore Aboki and another versus Attorney General, where he was just from the village. According to the Witchcraft Act, his property was burnt down, and the Constitution held that every person has a right to property. So the Witchcraft Act Section 3 was repealed because it was inconsistent with the provisions of the 1995 Constitution. We have a video of streamers of the Constitution on our channel. You can look for it. So, number 2, Professor Dicey said that there should be equality before the law. And if you go to the 1995 Constitution, Article 21 stipulates that all people shall be equal under and before the law. You can also look at a number of cases which stipulated and called for equality before the law. Sharon Dimache versus Makerere University. So, in that case, she was claiming that the Adventists were treated unequal with other students because on their day of worship, the university had teaching programs. You can look at that case. It points out equality before the law. You can look at Professor Dicey's idea, number 3, that there should be a just government. And that one, how can a just government come in? A strong government. What creates a strong government? When a government does in accordance to the law, it shall be feared. Every person shall correspond to its ideas. You can look at Article 28, a right to fair hearing under just government. Now, those were Professor Dicey's ideas, and we have married them with the 1995 Constitution. So, in 1959, the International Coalition of Jurists, an international non-government organization devoted to human rights, based in Geneva, expounded and laid down a number of other elements of rule of law, because Professor Dicey only laid down theory, but for them, they enlightened more about the rule of law. And their principles included the following: independence of the judiciary should be respected. For them, they said that for rule of law to exist, the judiciary should be independent. And if you go to the 1995 Constitution, Article 128 stipulates for independence of the judiciary, and it lays down a number of principles which emphasize the independence of the judiciary. The judicial immunity, the non-interference, a number of them. They also said that the judges should treat themselves in an honest and respectful way. So there are a number of cases which also emphasize the independence of the judiciary. I urge you to look at the case of Masaru Musene versus Attorney General, a very interesting case on independence of the judiciary. So, if you continue to another element of the International Coalition of Jurists on the rule of law, it said that there should be a strong and effective government. What creates a strong and effective government? When the government treats itself in the line of law, in accordance with the law, all people shall give their allegiance to that government. For example, now, in Uganda, I'm going to give a very clear and specific example. The president of Uganda has issued a number of policies in COVID-19, he issued the quarantine, but he did it in accordance with the 1995 Constitution. The Constitution provides for it. He himself is bound by the law. He cannot issue a law which the Constitution does not provide for. So we shall go to another one, equality before the law. We have talked about that one. Let us just mimic here. And Article 21 stipulates for equality before the law. We talked about the case of Sharon Dimache versus Makerere University. And to go on another one, the International Coalition of Jurists said that there should be a democratic government. So, what is a democratic government? This is a government which is representative, a government which has free elections. For example, in the 1995 Constitution, Article 59 gives Ugandans the right to vote. And Article 1 of the 1995 Constitution stipulates that the people of Uganda shall choose the leaders of their choice. So if you go to another element of rule of law according to the ICJ, you can look at the respect of human rights. In the 1995 Constitution, human rights are provided for under Chapter 4. You shall find that there are those rights that cannot even be limited, the non-derogable rights in Article 44 of the 1995 Constitution. For the rule of law to exist, there should be respect for human rights, because human rights are universal entitlements. They are not given by the state, but a person is born with them. That is the definition according to the case of Reverend Christopher Mutikira versus Attorney General of Tanzania. So you can continue to another element of rule of law according to the ICJ, sound and effective principles of administrative law. So for rule of law to exist, administrative law should be sound and effective. The administrators should do in accordance with the law. They should not act ultra vires. They should not act beyond their powers. They should not act with favoritism. They should act with natural justice. And the last one, respect of the principles of international law. So, for rule of law to exist, there should be respect of the principles of international law. Because the ICJ itself, it is an international law. But we are respecting it and we are learning from it. Now, how do you criticize? How do you give the negative side that the government has not observed the rule of law? You can talk about many instances where people are given bail and the government interferes. People are given bail and they are rearrested. Where the president interferes in the work of the judiciary of recent, where he interfered in the case of Kizza Besigye, where he emphasized him being tried in the military court. So I don't want to go more politic, but you can go back to our video of separation of powers. That criticism is there. I thank you very much for watching. Share to your friends if you find this information helpful. This is Legal Mindset at the Bar.